Physical property is defined by a hard limit. If one person occupies a space, another cannot. It is strictly exclusive and rivalrous. Intellectual creations don't follow these physical laws. An idea is non-rivalrous. One researcher applying a mathematical formula doesn't prevent another from using that exact same formula simultaneously. This legal taxonomy illustrates how the law formalizes this division. Tangible property branches off completely from intangible property. Following the intangible branch down, we reach the specific domains of intellectual property and trade secrets. Expanding that intellectual property node on the diagram reveals the primary subcategories governing commercial and academic research and development. Among these, patents, copyrights, and trademarks form the core infrastructure we will be stress testing today. The digital frontier has fractured these historical frameworks. Modern architectures, specifically APIs, generative AI, and big data, break the established rules of ownership. Doctoral researchers and engineers rely on 21st century research pipelines. To protect that work, they must understand the 18th century philosophies courts still use to judge it. We can test how digital tools break IP by mapping out the historical philosophies against modern contradictions. First is John Locke's labor theory. This justifies intellectual property as a direct reward for human effort, historically applied in law as the sweat of the brow doctrine. Second is the personhood theory from Hegel and Kant. This argues that expressive works receive legal protection because they are an inherent extension of human dignity and the creator's will. For centuries, traditional academic research neatly satisfied both requirements. A researcher supplied the intellectual labor, and their written expression demonstrated human will. Generative AI completely automates the sweat of the brow. A machine can instantly output complex data structures and written analysis without any human effort. Because this machine-generated content lacks human will or personality, it directly contradicts the classic axioms required to grant property rights. The current global legal consensus reflects this contradiction. Content generated exclusively by an AI is denied copyright and relegated immediately to the public domain. This creates a critical gray zone for modern doctoral candidates using generative tools to assist with drafting or data visualization. To claim ownership, a researcher must cross the threshold of originality. This is the strict legal requirement that a human must significantly edit, refine, or localize the AI's output to establish actual authorship. Relying entirely on AI automation without maintaining a human in the loop actively strips the resulting work of legal protection and commercial value. The third philosophical pillar is utilitarianism, originally championed by Bentham and Mill. Under this framework, IP is not an inherent moral right. It is a temporary economic monopoly designed specifically to incentivize the high costs of research and development. Software code severely stresses this theory because it operates simultaneously as a written literary work and a functional machine part. This tension culminated in a decade-long lawsuit between Google and Oracle over the Java API and the Android operating system, eventually reaching the United States Supreme Court. To resolve the dispute, the court defined a critical technical distinction, starting with implementing code. These are the detailed, specific instructions that actually execute a task on a computer. They contrasted this with declaring code, or APIs. Declaring code acts as a taxonomy, a shorthand, or a Dewey Decimal System that programmers use to call up the implementing code. Google copied 11,500 lines of Oracle's declaring code. They did this so that programmers familiar with the Java system could easily transition their existing skills to the new Android platform. The Supreme Court applied the four-factor fair use analysis to determine if copying this code was a legal infringement. Looking at Factor 2, the nature of the work, the court determined that declaring code is inherently functional. Because its primary purpose is operational, it sits further away from the core of copyright protection. Evaluating Factor 1, the purpose of the use, the court found Google's integration to be transformative. Instead of merely duplicating the original, they used the API to create a completely new smartphone environment. The court ultimately ruled in Google's favor. From a utilitarian perspective, strictly enforcing copyright on functional APIs would have created a lock on programmer talent and halted technological progress. To foster interoperability and market innovation, the law intentionally provides thinner IP protection to functional system architectures than it does to expressive implementations. This tension scales up significantly when moving from structured software to the unstructured, high-velocity environments of big data and the Internet of Things. Here, we introduce social planning theory. This framework contrasts the ideal of a democratic cultural commons against the reality of proprietary data silos. There is a major misconception regarding massive datasets. In most jurisdictions, raw facts and raw data points cannot be copyrighted or legally owned. Because the data itself cannot be owned, the digital economy has shifted to a system of access control. The European Union handles this through the sui generis database right. This protects the substantial financial investment made to obtain and organize data, enforcing it through digital locks and strict contracts rather than standard copyright. This access paradigm is currently clashing with generative AI developers, who rely heavily on data scraping to train large language models. Traditional text and data mining merely extracts semantic facts from a database to identify trends. Generative AI, however, is syntax-hungry. By absorbing the exact expressive style and structural formatting of the training data, it directly implicates a creator's reproduction rate. The breakdown of ownership extends beyond training data and into virtual asset control, specifically the enforcement of trademarks in the metaverse. This was tested when a digital artist created faux fur NFT handbags based closely on the famous Hermès brand. The artist defended the project under the Rogers test, arguing the NFTs were a form of protected artistic expression and social commentary. A Manhattan jury rejected this defense. They established that NFTs are classified legally as commercial goods and that physical trademarks are fully enforceable in virtual spaces. Whether a firm is securing an unstructured NoSQL database or policing virtual goods, modern intellectual property is no longer about owning the creation. It is about legally and technologically gatekeeping access to it. Surviving this digital IP landscape requires a specific strategic playbook. Rule number 1 addresses the highest risk for STEM researchers, the peril of public disclosure. Publishing a dissertation, presenting a poster, or detailing a technology publicly before securing a provisional patent permanently destroys the legal ability to commercialize that invention. Rule number 2 governs generative AI. Major academic bodies and scientific journals strictly prohibit listing an AI as an author. Researchers must maintain transparent documentation of their human-in-the-loop editing to prove both academic integrity and legal ownership of their outputs. Rule number 3 shifts enforcement to the platforms themselves, driven by new global standards like the European Union's Digital Services Act. Brand owners and researchers must now act as, or collaborate with, recognized trusted flaggers to utilize rapid notice and takedown mechanisms, bypassing the need for slow, traditional litigation. The future of research and development is a perpetual balancing act between the private incentive to invent and the public right to interoperate. For the modern doctoral scholar, mastering these legal boundaries is now just as critical as their scientific expertise.